Vital records are government registrations of the key events in any person's life. Strictly speaking, by definition, they cover only births and deaths, but for our purposes, we typically include marriage and divorce as well. Now, from an official point of view, vital records are created because they're helpful in identifying individuals for legal purposes, for compiling statistics about population trends, assembling public health profiles, establishing paternity, maternity, and marital status, and determining the age of individuals for purposes of eligibility for public programs like Social Security or Medicare. Therefore, verifying legal rights, obligations, privileges, and protections linked to age or relationship. But for our genealogical purposes, they provide easy access to our lineages by telling us who is kin to whom, in what degree of relationship, and when and where these relationships originated. They provide us with the dates and locations that frame our research questions. But frequently we find ourselves working in time periods when vital records were not required. In most American jurisdictions, birth and death records were not kept until the 19 teens. In some places like Pennsylvania, New York, or South Carolina, even civil records of marriage were not required until the early 20th century. Aside from New England, there are no widespread and comprehensive civil registrations of vital events in the 18th century or before that. And then there are the situations in which records exist, they should exist, but the record keepers or the subjects of the records were not engaged in that process. There are even times when records were actually made, but then they were lost because of maybe a destructive cataclysm, custodial negligence, poor storage, and the like. So how can we demonstrate that births, marriages, and deaths took place and assign at least estimated dates to them with some degree of accuracy in cases like the ones I've been talking about? Well, it's certainly not impossible. Then again, it's not always as easy as we might wish. Let's look at some workarounds for when records of birth, marriage, and death are lacking. Private records like obituaries, Bible records, private letters, and cemetery records, they're just too obvious for me to spend too much time on them. I just caution you to take a look at the original record if you can in every instance. What's the most obvious reason for doing that? Well, the original could have been misread or misinterpreted. But there are some other, more subtle pitfalls as well that you might want to be cognizant of. For instance, you always want to get the copy of the pages from a Bible record. See if they are written by the same individual throughout. From the publication date of the Bible, you might be able to tell whether the record was contemporary to the events it was describing or not. And if not, is this a copy of an older record or merely a recollection? See if you can identify the individuals who created the record from their handwriting. Is there reason to doubt the writer, the person that we would call an informant? Could the Bible have been ginned up or forged for a particular reason? Don't laugh, that happens quite a bit, particularly when people are trying to get into lineage societies. Could it have been well-meaningly expanded upon later by someone trying to be helpful, but who didn't really live at the time the events described happened, and so that's all secondhand information and more liable to error? When it comes to gravestones, check out that inscription yourself. Evaluate the style of gravestone you're looking at and when it was likely to have been erected. Was it erected at the time the person died or later? And if it was later, you can bet that a good bit of the information could be incorrect, including the dates. You must compare in those situations all the dates against other records. You'd be surprised by how much incorrect information from such seemingly infallible sources is out there. Here's an example from my family. A lot of people have never visited this graveyard. It's a little graveyard located near a home, a private home in the edge of a field. And originally there were no stones there. But someone in the 20th century decided that they were going to put up stones to some of the people that they knew were buried there. However, they didn't have the information about who those people were from a proper source. In the case of these three siblings that you see at the top, they never married, they lived on that farm their whole lives. There are no dates at all, and that's fine. But clearly that stone is not from the time period when these people died. It's a 20th century granite marker. And the original stones probably never were there. All these folks died, except for one of them, before 1900. Now, their father and mother also have a stone erected to them with the information you see at the bottom for the father. John Alexander McCrae, born 1783 in Scotland, died the 30th of January 1852. Everything about this record except the name John and the name McCrae is incorrect. This man, we can tell from an estate record's middle initial was R, not Alexander, but R, and the date of death was sometime in 1843, according to a petition filed in his estate record. So, though well-meaning, if you didn't actually go to visit the cemetery, but merely observe what was online on Find a Grave, you'd be completely misled about whether this was an original record or not, and it's not. Now on to some more challenging research avenues. U.S. federal census population schedules, particularly from 1850 forward, can be used when you're seeking an estimated birth date and sometimes a birthplace. But that birthplace is usually no more specific than a state, with some very limited exceptions. Of course, reported ages vary in the census in their accuracy. They're supposed to be given in relation to the census date. That is, the date to which the data collected in the census was officially supposed to apply. So the census taker was supposed to ask who was living in a household on a particular date in the census year and what was their age on that date, which is usually not the date that the census taker visited the family. The census date appears at the top of each page on the pre-printed forms on the later 20th century records and some of the late 19th century ones. On earlier ones, it can be determined with a little research. There are other accuracy issues. We don't know, for instance, who gave the information for a census report until 1940. So did the father or mother provide the names and ages? Or was it maybe one of the children, or even a neighbor? Without knowing who gave the information, we're not quite sure about how accurate it could possibly be. That person's knowledge is key to evaluating the question. Did someone fudge their age slightly, older or younger, because of vanity or uncertainty? Without knowing the informant, it's hard to judge accuracy, as I said before. It's not uncommon to find great variance between reported birth dates for an individual across several census years. So in general, it makes sense to privilege information that was given earlier in a person's life. And we can decide to take an average of the various reported ages across the censuses and use the word circa, C-I-R-C-A, or the abbreviations C period or maybe CA period before our reported date. And that communicates that we're not absolutely sure, but we are using an estimate. Or we can even use a date range instead of a precise date if that's warranted, and you should do so if you have some doubt. Earlier census years, those prior to 1850, only list the head of household by name, and then every inhabitant of the household is assigned an age range within a gender category. A lot of people throw this kind of census data away. They just think it's useless, but it's not. It is, of course, an assumption which tick mark in the pre-1850 population schedule refers to which inhabitant of the household, but usually one can deduce with the help of other records which person is which. And if that is the case, it becomes possible to narrow a birth date down to a range of 5 to 10 years, even if the individual did not survive to 1850, by comparing ages across several years. And here's an example of where I've done that with my ancestor Samuel Allen, who only made it to 1831 and lived in Montgomery County, North Carolina, where one census record, the 1820, is lost. But I still can, by using these different census dates and age ranges, I can get him down to being born between 1770 and 1774, and that's probably pretty accurate. Marriage dates can be indicated by census data in a rough, inexact way. Marital status of each individual was asked in 1880 and afterward, and the 1900, 1910, and 1930 censuses even asks the number of years married or the age at first marriage, and often indicate whether the union is a first or a subsequent marriage. Rough years in which the marriage took place might be estimated using this data, or a marriage year could be estimated by backdating from the birth estimate of the oldest child living in the family in the first census year the couple appeared together. However, keep in mind, many oldest children were conceived out of wedlock. Also, the first census year of the marriage will not record an oldest child who died before that year. So the marriage could predate the estimate by a considerable amount or postdate it somewhat. Also, some of the children could have been by a prior marriage, whether the reported surname indicates that or not. It's useful to keep these caveats in mind. Now, some people tend to use census material to estimate dates of death as well. And certainly an individual may appear in one census and not in the next one, and the assumption could be that the individual died in the intervening decade. If some of that individual's children were born in that decade, one might further narrow the range for an estimated date of death. However, this is not in any way an exact approach. It's possible that an individual was not present in a household because they're working elsewhere, had divorced their spouse, or abandoned the family. They could also have been omitted by mistake. In the final analysis, absence from a census report cannot prove death, even if the wife or husband gives a marital status of widower or widow, because that could be a cover up for divorce or abandonment. In the example that you see on your screen, for a long time, I assumed that my great 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 grandmother, Nancy Reeves, had died between 1870 and 1880 because she was there with my great great grandparents in the 1870 census and was absent in 1880. But it turns out she actually moved with out west to Smith County, Tennessee to be with her son Lucian Smith, and she's buried there in 1898. She actually made it to be 92 years of age. I would never have known that. The 1890 census, of course, is missing, has been lost in a fire. So I have found her gravestone, and it is in Hickman in Smith County, Tennessee. There is a special report in the 1850 to 1880 censuses, however, specifically intended to gather information about family members who died in the preceding 12 months prior to the census date. So usually that was from July of the preceding year until June of the census year. These are the mortality schedules. So if you're lucky, you may find an ancestor here, the month and year of death, and the cause of death. In 1850 and 1860, even enslaved ancestors may be recorded in the mortality schedule. And you see this example from Montgomery County, North Carolina, where a person I was studying named Mary McCrae Sr., 73 years old, is said to have died in August of 1849 of dyspepsia. But you also see some enslaved people here. Her enslaved lady Molly, 50, also died during that year of dropsy. And further down, you can see N.B. Miller's Jerry, 4 years old, dying in September of 1849. If you know what church your ancestor belonged to, see if you can find records from the period during which they attended. Now, usually these are in the custody of the church itself, and you might need to find the church historian. Individual congregations often have one, maybe official, maybe not. But such records might have been handed into an official repository, like a diocesan or denominational archive. Some may still be in private hands, like among the descendants of ministerial families. Some may have been transcribed into a local genealogical journal and published years back, because that's genealogical gold. For genealogical periodicals, it's always a good idea to check the Percy Index on Find My Past to see if there is an article about that church in some local genealogical magazine. Now, we all know the good churches for vital records information: the Friends, Presbyterians, Dutch Reformed, German Reformed, Lutheran, Catholic, Episcopal, or Anglican. In these contexts, you can be pretty sure vital records of some kind were kept, if they have survived, and if you can only find them. And they're not just baptism, marriage, and burial records. Churches that required confirmations at age 13 or 14, for example, might keep lists of young people coming into their full age of accountability year by year. Even if the christening doesn't exist, the confirmation list is an indicator of age. But even the bad churches who didn't keep vital records routinely may have nevertheless kept some records of interest. I say bad in quotation marks. Bad from a genealogical point of view. Are there sexton's records for burials in the Baptist or Methodist cemetery? Are there membership lists on which people's names were struck off as they died? In the primitive Baptist church, I've seen people's death dates given in this way in session minutes. Were some prominent parishioners eulogized when they died in those minutes? Or did their obituaries and marriages appear in sectarian newspapers rather than the secular newspapers? Were church members disciplined for out-of-wedlock births or extra-denominational marriages? These may indicate when these particular births and marriages took place. Now, quite obviously, a probate packet is by its very nature associated with death. Someone has died. Therefore, their property and debts have to be tallied. A balance has to be determined so that their heirs can receive their proper portions. Now, if the individual left a will, and we call that person testate if they have a will, you can bet that he or she died between the date the last part of the will was written and signed and the date the final document was submitted to the court for recording. The date of the will is obviously found within the text of the will itself. And remember that codicils may have been added later to revise the will, and they too will be dated, but slightly later than the will date. The probate date is usually recorded in the will book itself right after the text of the will. That's when the will was brought into court to be recorded. So the person is dead by that date. It might also be written in the copy of the original will on the foot of the will or the reverse side of the paper. If not, the minutes of the court overseeing probate almost always note when a particular will was brought in to be recorded. If the individual died intestate, that is without a will, you can still often estimate the date of death from the earliest record filed with the court in the probate file or packet. Some petitions to the court in a probate packet, like petitions for division of real estate among the heirs or petitions for dower or thirds of the widow, may actually refer to the precise month and year of the deceased passing, or sometimes even the precise day. Accounts submitted for final medical services or burial costs may indicate when someone died, better than anything else in the packet. But in the absence of a precise indication, consider this. Court sessions were usually held 3 months apart. Starting with the date the estate is first mentioned in court materials, it's a good bet that the individual had died since the prior session of the court. Oftentimes, the first record filed will be the administration bond for the person tasked by the court with settling the estate or the application for such letters of administration. The widow's death may also be indicated by her husband's estate packet. Since widows had lifetime rights in a third of the real estate of their late husbands, and we call this dower, by the way. When you see the heirs disposing of or dividing her portion, either in a deed or in the estate packet itself, you can bet that she had died quite recently. That is why there is frequently a big chronological gap in the sequence of documents within any one probate packet. There may be one portion relating to the exact death of the man, and then a later portion that happened after the death of the woman. Or there may be two packets entirely dated at widely different years with his name on it. One for when he died, and a later one reflecting when she died. Indications of birth, oddly, may also be found in probate materials. Minor heirs' ages are key to determining how long their guardianship lasts. For girls, 18 was the age of majority, and 21 for boys. Also, children could often choose their own guardians at age 14. So when you see final settlements made with children under guardianship, or children choosing their own guardians, you have a clear indicator as to their ages. Finally, wills and estates records often list children in birth order. Not always, but quite often. Sometimes males and females are listed separately in gender-specific birth order. Order may help you determine something about when these children were actually born if they're collated with other sources. Guardianship records aside, courts are often interested in ages of individuals for legal purposes, and deaths are sometimes linked to matters before the court. Naturally, the court is interested in mysterious deaths and murder. There are more of your ancestors waiting for you in coroners and criminal records than you might imagine, and you simply wouldn't know they had died mysterious deaths without referring to these difficult to access records. I have several examples in my own family tree. God forbid, an ancestor could have been executed because of a felony conviction. Pursuit of the court record could indicate precisely when that happened. If a person is bringing a legal suit or being prosecuted criminally, a death will automatically terminate the issue. That's sometimes seen in court minutes and referred to as an abatement. The death would have occurred since the last time the case had been heard by the court. Apprenticeships, by which orphaned or indigent children learned trades and were assigned a master, always indicate the age of the child at the outset, so as to know when the period of service should end precisely. The age might be inexact or purposefully incorrect, however, in order to lengthen the term of service, and that's particularly true with children of color. Bastardy records for illegitimate children indicate around about when the child was conceived or born, although the child's name is not often given in these records and has to be deduced. Depositions and affidavits may give the deponent's or affiant's age, so as to give greater weight to their testimony. If they were old enough, it was thought they were in a position to know what they were testifying about. A person's first or last appearance in a relatively complete series of tax records may be an indicator of when they were born, because young white males were not taxable until age 16, and individuals over 60 were often exempt from capitation taxes. Free black people and slaves were eligible to be taxed for a much longer period of their lives. Tax records also sometimes are the only indicators that a person has died, because their widow, executor, administrator, or heir suddenly appears in possession of their property from one year to the next. This is particularly true in the colonial period, because land automatically passed in many places to the eldest son in intestate estates with little fanfare. In the absence of a son, it would be divided among the daughters equally. You might also see this transition in ownership from original owner to heir in two sequential deeds, even a deed that pertains to a neighboring property, which just happens to mention your ancestor's land in the meets and bounds. So in one deed in 1745, for example, John Smith might be listed as the owner of an adjacent parcel in a deed. In 1748, John's eldest son, Wallace Smith, might be listed as the owner of the same property, or it might just be described as the estate of John Smith deceased. Either way, we now know that John died between 1745 and 1748, and that's more than we need to start with. A young woman whose father is relatively wealthy may be seen giving her something by deed of gift just prior to her marriage, or to the young couple just after they were married, usually in a deed. This in itself is an indicator of when the marriage likely took place. And finally, a woman's death may be indicated in a jurisdiction where inchoate dower prevails when she's no longer appearing signing her husband's legal instruments. Dower is basically a woman's lifetime right to the enjoyment of a third of a husband's real estate after his death until her own death. So inchoate dower means that she had the right of prospective dower even when he was alive, and so her consent had to be obtained every time he alienated some of his land. So if she stopped signing the deeds under these circumstances, she's probably dead, and her death can be marked as happening since the prior date that she actually signed one. Sometimes, especially in the 18th century and before, the best way to determine estimates for the three key life events is by creating a timeline for the ancestor in question based on all the records you have. You'll often have to go deeper into the records to flesh out your timeline with more events. Don't forget to include the births of the eldest child and the last child. For a woman in particular, the last child could herald the onset of menopause and therefore provide a rough birth estimate for her. You definitely want to include the first time the male ancestor was ever mentioned in a public record as a witness, recording a flesh mark for livestock to distinguish his animals from others, buying land or selling it. That might be the time he came of age or became legally competent to perform some of the legal actions that he's taking, or performing some of the public duties he's expected to undertake. The ages for all these things, these activities, they're prescribed by the laws prevailing at that time. You want to include the last record you found them in as well, and the next record in which you would expect to find them, but from which they were absent. They certainly died after the first date and before the next census or tax list if there's no evidence they moved elsewhere. In your timeline, include everything you can locate from the record categories that we've been discussing and more. When you do this, it may be pretty easy to estimate all three important dates at the very least. Of course, there are far more sources that can give indications of birth, death, and marriage than I can practically mention here. It's nearly impossible to imagine or cover them all, but hopefully I've given you some ideas about how to bridge gaps in the records that you've accumulated and construct estimates of ancestral vital statistics when such records per se are non-existent. I'm going to be trite for a minute. The old adage is very true. Where there's a will, there's a way. Even if you don't have all the dates you need from the most obvious sources, deeper research can often fill in the gaps with adequate alternatives, particularly when you're working in a records-rich environment. It just takes a little effort and a little imagination.